That's good. Okay, so welcome everyone. This is the next installment of our tacos and term sheet workshop. And today we are going to review and discuss an M&A term sheet. So we're going to start at the top of the term sheet and go all the way to the bottom and explain some of the typical terms that you find in this type of term sheet. First thing, some logistics. In person for the tacos and networking. It's 12:15, so we're starting the presentation and also the companion webinar. And the presentation will go for about an hour. And we'll have ample time for Q&A, so get all your questions ready. And we'll have some more networking and probably some more tacos afterwards if you're so inclined. Just a quick introduction of the team. You may have met Carly and Marty back there. They were instrumental in getting the tacos and a lot of the logistics going for the work for the workshop. Jamie is an experienced M&A attorney who's running the webinar and helping with a lot of the technical aspects. And Matt and I will be giving the presentation today. So, mergers and acquisitions, one company buys another, very simply stated, right? And so, there are different alternatives that you typically see in an M&A situation. There's one company buys the assets of another company, right? And typically might be with some of the liabilities behind. A stock sale, you buy all the stock from the stockholders of the company and then become the owner of that company. And then there's also a merger. We won't get too much into this, but there's a forward triangular merger and a reverse triangular merger. And the term sheet that we're going to go through today, and we'll talk about it more, is a reverse triangular merger. So in preparing this, we thought it would be good just to give you kind of a rundown of some of the typical steps that you see in an M&A deal. So the first thing is that the two parties need to get together and see if there might be a fit to explore actually buying and selling the company. So initial discussions, think of it as dating and kind of getting to know each other and seeing if there might be a fit to move forward. After that, things get a little bit more serious, and it's time to put a non-disclosure agreement in place, right? Because the questions are getting more specific. You're starting to deal with confidential and proprietary information, some of the secrets and secret sauce. So the parties will negotiate and document and sign a non-disclosure agreement to keep everything confidential. After that, business due diligence starts, right? You have the NDA in place, so you can start showing the purchaser behind the curtain and opening up the books and sharing more about the company. We refer to this as more like high-level due diligence, right? Again, the buyer is kicking the tires and trying to ascertain whether there's a deal to be done. But through that process, they've gathered enough information and the parties now know each other where they decide, okay, we're going to put a term sheet in place. We're going to outline the deal and see if we can reach agreement on the principal terms so we can move forward with the acquisition. And so our deal, this is a copy of the term sheet that we'll be reviewing. We've given it the code name Project Taco. But this is a very important step, and we'll get into this in much more detail, but this is a very important step in the deal process. After that, there's more in-depth due diligence where the buyer is going to really start kicking the tires hard, looking at the contracts, understanding the customers, really getting into the prospects and also the issues and challenges that acquiring this company may present. Then there's the deal document. So by doing the due diligence, the buyer is starting to understand, well, where are the risks, what things do I need to account for, which employees do I want to move over. So they start to understand the business that they're acquiring, and with that information, that extra kind of more in-depth due diligence, they're able to prepare the merger agreement and all the other companion deal agreements that need to be prepared and negotiated to get the deal done. After that, the deal documents are signed, but the deal hasn't closed. Right? There may be some conditions to closing. So the acquirer, for example, may need to get financing, get a bank loan so that they can buy the company, or you may need to get regulatory approval. We'll talk more about the closing conditions. just want to make the point, though, that just because you sign the documents doesn't mean that you've done the deal yet. So there could be these conditions to closing the deal. And lastly, the deal is closed, right? The closing conditions are met, money's exchanged, and you move forward with the deal.
So today we're focusing on the term sheet, and when we talk about term sheet, we're also referring to a letter of intent or a memorandum of understanding. We're really using those terms interchangeably here for purposes of this discussion. It really is a roadmap to the deal, and it will, a theme that we'll touch on a lot in going through this is an M&A deal is a lot more in price. Although it's understandable and will happen that business folks will tend to focus on price and have will toss around a number and they'll think they're most of the way there to negotiating their deal. What we really counsel our clients to do, really both buyers and sellers, but particularly sellers, is to really focus on this stage, the term sheet stage. It's critically important. It is, we'll get into it later, but it is really the time to negotiate the important terms from the seller's perspective, and in most cases it's the time when the sellers can have the most leverage to drive terms. So talk a little bit about that as we go on. So stepping back and understanding the kind of general timeline for an M&A deal, as Carlos mentioned, from kind of the initial discussions to getting to the point where you can, arrive upon a price and maybe some other terms, typically 1 to 3 months. It can, companies will dance for 6 to 18 months too. That has happened, and it can, can obviously be shorter or faster, but I think that's a good range for that period. And negotiating a term sheet, again, I expect a term sheet to go back and forth a number of times. It's really much more than just, it will be the backbone and the roadmap to, a transaction that can take 1 to 2 months. After the term sheet's signed, the intensity will often ratchet up, and the parties will do, legal and business due diligence, more in-depth diligence, work on the definitive documents. That, can take 1 to 3 months,
or a lot longer.
Or a lot longer, or Bear Stearns was sold in a weekend, and so it can be shorter too. But this is a typical. And then at this point, at getting into the blue is typically where the deal has been signed, but it's subject to closing conditions. And so you have a definitive document, but you're waiting on getting approvals, consents, financing, other closing conditions, and that can take. You have a simultaneous sign and close if there are no closing conditions that you have to go out and get, or it can take two or longer. If you have antitrust approval, for example, that is typically where you see deals that take more than 2 months to close after signing.
We average 1 week to get our deals done.
Yeah. Currently on it, and so I think too, just in looking at this, stepping back, I'd say right in the green is where companies will typically experience some sort of deal fatigue and will be extremely tired of talking about their due diligence and oftentimes going over the same information, multiple times. But it's important to understand the process and sort of, it's a marathon, not a sprint, as they would say, so that you can avoid that, because there's a ways to go until money is wired into bank accounts at point 8 here. So just starting at the highest level of term sheet sets forth the current intentions between two parties. Oftentimes you'll have, occasionally you'll name a term, name a deal, give it a code name because for confidentiality reasons. So we've worked on Project Diamondback, Project Saddleback, Project Mercury, and so on. This is today we're talking about Project Taco. So again, the term sheet is really it's going to summarize the key terms of the M&A transaction, a lot more than just price, and is the roadmap for preparing, the longer set of definitive documents. So if you think about a term sheet as maybe, this term sheet might be 7 or 8 pages, the definitive agreement might be 70 or 80 pages, and so it's real important to have that conceptual agreement on kind of the major components of the deal.
But when you take all the agreements together, there's well over 200 pages, right?
Yeah, hundreds of pages. So the general rule on a typical term sheet would be that the term sheet's not binding. It's a binding agreement doesn't occur until you have a definitive agreement, with a couple important exceptions that we'll go through and flag as to provisions that are binding, pursuant to the term sheet. We'll go through those.
Okay. So a few slides back, we talked about the alternative types of M&A transactions, and this is the first section of the term sheet. It talks about the structure of the deal. Just a kind of a deal comment. We've been involved in many deals where they say, oh, we're going to do an asset deal, or we're going to do a stock deal, and they even actually start preparing documents, and then they finally decide to look at it from a tax perspective or some other perspective, and say, no, we want to do a different deal. Right? So, and then you have to do all the documents over, and you don't start from point zero again, but it's not the best situation to be in terms of timing and cost. So it's really important to early on get the tax advice, have a discussion about the structure, what makes sense for the deal. In this term sheet, we're talking about a reverse triangular merger. This is a short paragraph, so I can read it. So a reverse triangular merger is whereby a wholly owned subsidiary of the purchaser will merge with and into the company, with the company surviving the merger as a surviving corporation. So we did some fancy graphics here, so this will help explain this. So we have the purchaser wants to acquire the company, right? And the purchaser forms this purchaser sub, a wholly owned subsidiary. And the next step is the purchaser sub merges into the company. So it moves over. And once that merger happens, the company then becomes a wholly owned subsidiary of the purchaser. And so this is what's called a reverse triangular merger. Sounds fancy. There are various reasons why people do deals this way. A couple of them would be the original company that's getting sold survives, right? So all of its contracts are still with this company. It's not like the contracts have to be changed over to the purchaser sub. So it keeps a lot of the existing contractual and other relationships in place. There could be, for example, permits and other things that the company has that you don't want to lose. The other thing is, if you were to do a stock sale, the buyer wants to own the whole company, right? So if you have 50 stockholders and you're doing a stock purchase, you've got to buy the stock from everybody. You can imagine you get to stockholder 48, 49, and 50, and they haven't agreed to the deal. They have a lot of leverage in the process at that time. But by doing the merger, you don't have to get 100%. You can pull along their deal conditions, and we'll talk about that. But you can pull along, make the deal happen with less than 100% of the stockholders saying okay. Right? They have certain rights to challenge the deal. It doesn't really happen that often in the private context, but those are reasons why the reverse triangular merger is used.
So total consideration, this is one of the most important slides in the presentation. This deals with the deal proceeds. And it will start with kind of the top line number. This is the number that most parties will focus on, in this case, 50 million. But this deal, like most deals we work on, is going to be done on a cash-free, debt-free basis with adjustments that we'll work through. So start out with 50 million, subject to dollar for dollar reduction for the company's debt and transaction expenses. So that would include lawyers' fees, bankers' fees, and also in that sort of definition, you'd see payments that the company needs to make that are triggered by the deal. So if folks get change of control bonuses, that's going to come out of that purchase price. The buyer wants to spend no more than 50 million and not have to assume own a company with extraordinary liabilities. And so there'll be that dollar for dollar reduction. Increase for cash and cash equivalents, but that really works hand in hand with what a positive or negative adjustment for the company's working capital. And so then the purchase price is based on various assumptions, including actually financial information. So to focus on here, I would say that it's important to understand how the deal proceeds will be divvied up before there's funds that are distributed to stockholders. Don't just assume the headline number is the number that's going to be distributed. 9 out of 10 times it'll be less. It will certainly be different. On the net working capital will be a peg that the buyer and this company will agree to as to how much working capital the company has at closing, with the idea being that in most cases a buyer doesn't want to buy an operating company and immediately have to fund working capital in order for it to pay its expenses and stay in business. And so there'll be some amount. In every company, this will be really different. Typically, you'll see working capital pegs being set on a 6-month historical average of the company's working capital. Here, a lot of times you'll see M&A term sheets that don't specify a working capital adjustment, or that just refer to it in general without actually establishing a target. I think from touching on our theme of really this is the time from a seller's perspective to negotiate and to maximize your leverage, it's really a good idea to have a plan with respect to working capital, and ideally come to an agreement early in the process. Don't wait until the end, because when that happens, there's almost never, there's always a fight, and the buyer will always come in with an expectation of a higher amount of working capital, and there's negotiation, and there's real dollars changing hands as a result of this.
Matt, can you just explain the mechanics of that net working capital?
Sure. So if the company, in this case, there's a working capital target at 5 million. So if the company at closing had working capital of 4 million, there'd be a $1 million shortfall, and that would come out of the purchase price to get it to the target. Likewise, if the company was still closing had 6 million in working capital, there'd be a net positive of $1 million, and that would serve to boost the purchase price.
So that comparison is done after the closing, right?
Yeah. So and at the closing, there'll typically be estimates with respect to these amounts, and the seller will deliver pretty good estimates, and then 90 days after the closing will be a post-closing true-up where the buyer will come in, look at the company's numbers, see what AR is collected, and settle on a final working capital adjustment.
Where's the money for the entire purchase price? Is it in some escrow account?
Well, so typically the purchase price would be paid off of the estimates, but yes, there would be an escrow. Sometimes there's separate escrows for working capital and for indemnification, or just one big bucket for the buyer can easily turn to. If it turns out that the company estimated, for example, that it had 5 million in working capital, but it really turned out to have 4.5 million, that 500,000, the buyer would have an opportunity to go to that escrow account and make up for it.
But the full 50 isn't typically put in an escrow.
No, so in this case, if there was no working capital adjustment, let's just say there were no adjustments, all 50 would be paid. Well, no, less than 50 would be paid at closing. Some amount, which we'll get into, would be put in an escrow, and we'll work through that as we on the next slide.
What if there's a surprise liability that comes up?
Well, let's cover that when we get into
Those are good questions. They're foreshadowing. Earn-out provisions, you may have heard about those. It's not in our term sheet, but we think it's important, so we're going to talk about it. So I have my company, right? I'm the seller, and I think it's worth 100 million, but the buyer only wants to pay 50. And we're negotiating. Eventually, and I'm saying, oh, we've got great prospects, our technology is going to be great, we're going to do all these great things, it really should be higher. And so there's a gap, right, between what I want and what the buyer wants to pay. So to bridge that gap, it doesn't always happen, but it does frequently, there's an earn-out provision that's put into place. And this is my way of short forming what this means. It's the buyer telling the seller, put your money where your mouth is, right? If you want this extra money, you will need to perform your future performance. If you meet the milestones that we agree on, that we document in the deal, I'll pay you extra money, right? So that is a way for the two parties to reach agreement as to value. And these milestones can be financial, you know, that next year the sales will be X millions of dollars. It could be earnings before interest, taxes, depreciation, and amortization. It could be a net income number. But there's various financial metrics or milestones that can be used to trigger additional payments under the deal. There could be commercial milestones about entering a new market or entering a new industry vertical and getting traction, commercial traction. And there can be technical milestones that a certain type of product performs to a certain level of specification, or patents are filed with certain claims. And we'll get a real-world example of how this plays out. Earnouts, though, a little bit of a crystal ball, right? The parties are agreeing that a certain amount of money will be paid in the future based on certain performance being accomplished. And so from a legal contractual standpoint, you really need to think through the earnout provisions, and you need really tight contractual provisions that are as black and white as possible so that the parties know when the money is and the payment is triggered. So the tension that you have, though, is I'm the seller, right? I have this earnout, and I want to do all that I can so that I get my extra $50 million. But when I sell my company, I'm no longer the big cheese. I don't control all the decisions. I might be, you know, a few rungs down the ladder. And I also may not have budgetary control, right? So I may not be able to throw as many marketing dollars at my issue as I would like to. So there's a tension and something to think about, and we've documented some provisions to address this, is how can the seller have enough autonomy and enough control that they have a good chance of getting their earnout, okay? Problem with earnout, I talk about the crystal ball aspect. There's a big increase for future disputes and disagreements, right? And I have a real-world example that I will share. Back in 2011, we sold a biotech client for $80 million. And at closing, what Matt just talked about, $20 million approximately in cash went to the selling stockholders. And $60 million was left in earnout. And they had actually all three. They had financial milestones, commercial milestones, and technical milestones. To date, they've received all their earnouts. There was a hiccup a few years ago where it was a biotech diagnostic technology. And so there's very technical terms in the earnout provisions about how this diagnostic had to have a certain precise level of detection. And there was an argument about that. The acquirer didn't want to pay the full piece of the earnout. They fought a little bit, and they eventually folded it, and the money went over to the sellers. Now, about 35 million, okay, of the total 80 million, or 35 million of the 60 million of the earnout relates to the issuance of patents. And so back in 2011, they said, oh, we're going to file these patents, and we're going to get them issued with these types of claims. So patents have been issued, but the claims are different. So the buyer's saying, well, they're a little bit more narrow than what you told us they were going to be. And the client is, or the company that was sold, their selling stockholder representative, saying, yeah, well, they're more narrow here, but they were more broad over here. So altogether, it's a better patent than what we originally contemplated. So that's a big fight. The acquirer isn't in the same financial position that it was 6 years ago, so they don't want to pay $35 million. They actually offered half. The selling stockholder representative has hired IP litigation counsel to help them argue this. So there's a lot of money on the table. I think they have a good shot at getting full payment. I think it's a lot driven by the fact that the acquirer as financially healthy as it once was. So we'll see, but that's a case where maybe to the extreme in terms of earnout provisions. They were tested once, they won. We'll see what happens on this next round. So that's our. This is something that if you do get to the point of selling your company, chances are this type of deal term might come up.
How long is it earnout?
You know, it really depends on the company, right? So this was a company that had kind of a platform technology. The products weren't in the market, and patents were being filed. So the earnout was multiple years. If it's a company where it has a software product and it could be as short as 1 or 2 years, right? Just to see what the financial results are, and if the results are healthy enough, then that will free up some money to pay the earnout piece. So really, I know that's kind of a wishy-washy answer, but it does depend on the company and its business.
Okay, so now circling back to address Steve's question about what happens if an issue comes up. Issues do come up, and in almost all cases, it's customary for a buyer to want to put some amount of the purchase price aside in an escrow account, typically held with a bank, to serve as a security for indemnification claims to the extent that liabilities do surface after the closing that were contemplated at the time of the deal. At a very basic level, buyer wants a large escrow fund that survives for a long period of time, so they have a sufficient amount of time to after the closing to conduct an audit, to continue to kick the tires, see what comes out of the woodwork that might impact the way they value the transaction. So I think, and touching back on the net working capital adjustment we were talking about, oftentimes an escrow will also be used to deal with that post-closing true-up, where depending on the accuracy of the company's financial information, additional funds will be available to compensate the buyer out of the escrow. I've seen term sheets where they don't even say the word escrow, or they say, the purchase price will be some headline number subject to, and a portion of that will be put in escrow. Touching on this theme of if it's important, put in the term sheet, specify the amount, because buyers and sellers will disagree on what's a reasonable amount of money to cover. Seller will say we haven't had any litigation in our entire existence. We have a clean company. All of our AR is very solid, etc. We want as much of our money now as possible. Whereas the buyer says, you'll get your money in time, assuming that's all right, but we're gonna put some of it in escrow.
Just to add on that, if you don't have a clean company, and when they kick the tires and dig in, and they see that there's a lot of problems, say, no, we don't want 10, we want 20% escrow. So a lot of this is influenced by the due diligence and how due diligence ready your company is.
And we were working, so we were representing a buyer buying a biotech company. It was closed around the new year. We were negotiating over Christmas break. The buyer and seller didn't agree on the amount of the escrow. Buyer prevailed, insisted on a significant escrow that ended up being about 10% of the purchase price. It might have been a little bit more. And the seller, of course, thought that was an outrageous amount of money to put in escrow, that it was really just totally unnecessary, and there's no possible way that unknown claims are going to surface after the fact that would anywhere approach that amount. As it turned out, literally a week after the closing, the company learned that some of its scientists had cut some corners and went around good manufacturing processes. A lot of details, but long story short, we ended up having a claim that was worth almost $200,000 and took that money out of escrow a week after the deal closed.
There was no fight.
There was no fight.
No fight.
Yeah. But it proved to be, it demonstrated the point that issues do come up, and the escrow served its purpose in that case.
Are the escrow fees typically borne by the buyer or the seller?
That's negotiated in every deal. It will either be the buyer will pay them, or the company, the partners will split it. I've never seen a seller have to pay all the escrow
Okay, so
fees.
buyer, but we're talking even it's
$5,000, you'd split it.
So it's real money, but it's not huge money. Yes.
Quick question, have you, I'm starting to see more like reps and warranties insurance coming into play instead of actual escrow holdbacks.
I've seen, I mean, it's big in private equity. They've done a couple transactions with reps and warranties insurance. It's for bigger value deals where in this case the seller was a private equity fund, and so it really didn't want to. It wanted to take the deal proceeds and distribute it to its limited partners, and wasn't really set up to deal with the 2-year uncertainty period where a portion of that purchase price could come back. And so what the company did is the company bought an insurance policy to cover its reps and warranties, which, you know, it in that case made the decision to spend almost $750,000 in that case to buy a policy, and that policy was the buyer's only recourse.
It's not cheap.
It's not cheap. And a lot of sellers would prefer not to have that. For that reason, they think, you know what, there's no way, you know, the cost of this policy, we'd rather just wait it out and get all our money back.
So section 4 of the term sheet has to deal with employee matters. And as you can imagine, many acquisitions, moving talent from one company to another is important, right? There's a case of many small software companies where the acquirer just wants to get the software engineers into their shop. And so those are called acqui-hires, and so those types of deals are focused on just moving over the employees. But when the purchaser does its due diligence, they're going to identify the CTO or the CSO or some people in sales that might be really important to the company after the closing. So they will identify them as key employees, and they'll say, okay, as a condition of getting this deal done, all those folks that we identify as key employees, they have to move over if we're going to close the deal. And for all of the other employees that aren't key employees, we want the lion's share of those people to move over, right? We want the company to still be functioning. We don't want to be left with the key employees and 5 people. So the purchaser, in this case, is being smart and saying, if I'm going to close this deal, these 2 things have to happen. I have to have the key employees move over, and I have to have, again, in this case, at least 95% of the other employees move over with the acquisition. There's a paragraph here. I need to advance here. There's a paragraph here that basically explains that when these employees move over, they'll be eligible to participate in the benefit and 401k plans of the acquirer. And there's also, this goes to Matt's comment. So we may not get all the employees to move over. We may meet the closing condition. Let's say 3% of the other employees don't move over. This deal point says, you seller, you have to take care of that obligation, those termination costs, those severance benefits, the vacation payments that need to be made before closing. Because we want those people out. It's on your dime. And so those are, again, money changing hand that's going to affect the balance sheet and possibly the actual amount of money that's distributed to the stockholders. Okay. So similarly, we talked about the 2 closing conditions for employees. But this, if you remember the deal outline, this is after the deal documents have been negotiated and signed. Is that period between the deal documents and the actual closing where money's paid, which are the closing conditions. It's pretty short form here in the term sheet. This idea that they're going to be customary, that's like add a few drops of water, that expands into about 15 or 20 things, right? So in the actual agreement that Matt mentioned, that's 70 or 80 pages, a few pages, or at least a page, will be closing conditions. And they can be closing conditions going both ways, right? The purchaser wants certain things done, and the seller likewise will want to have certain closing conditions. But from the purchaser's standpoint, corporate approvals. So in the merger transaction, we talked about how you don't have to get 100% of the stock, but you probably want to get a pretty high number. And so in the deal that Matt mentioned, the threshold was to get stockholder approval of 95% for each of for common stock and for each of the series of preferred stock. Because they just want to make sure that, there's a lot of momentum and support for doing the deal, and it really lessens the likelihood that there's going to be some complaints or challenges to the purchase price after the closing. There could be government approvals. Matt mentioned, regulatory approval or just various things that you may have to do given the type of business. You may have to get regulatory clearances. On the contract side, there are many what are called changing control provisions in contracts. So even though it's a merger and the seller is going to survive, because it is a merger and it's a change in control of the company, it may trigger a consent obligation or a consent right of the other party in the contract. So as part of due diligence, you may have to go back to those other parties in those contracts and get their consent to do the deal. That's not something that you want to wait until the last minute on, because that could take a long time depending on the contracts that the seller has. We already talked about the key employees and the other employees. Again, this is an outline of the deal. So the due diligence and what the buyer finds will influence the closing conditions that they will be required to get the deal done.
So, representations, warranties, and covenants. First on, if you've been through a financing, bank or equity financing, you should be familiar with representations and warranties. Representations and warranties are broad statements that speak to the company's business. Company, everything from this deal will not conflict with any of our material contracts, or this deal will conflict with only material contracts that are set forth on this schedule. We don't have any litigation. We don't have any disputes with employees. All of our employees are properly classified as employees, and all our contractors are properly classified as contractors. It'll be 20 to 30 pages of statements like that that speak to virtually every aspect of the company's business. And what will correspond with that is a disclosure schedule the company will prepare that will list all the different statements and facts that are necessary to make that true. So the company says, except as set forth on Part 7 of the disclosure schedule, we don't have any ongoing litigation. We have one ongoing dispute with a former employee, and we've told you about it. And so if in that case, a seller after the fact, or buyer after the fact can't come back and say, hey, we had to pay X amount of money to sell that claim, the company says, we told you about it. And you agree to assume that risk as part of the deal. Representations and warranties, real quickly, covenants are obligations on the company to do certain things, and restrictions on the company from doing other things. We're not going to tell anyone about this deal. We're going to go out and get these consents, and so on. During the time in between signing and closing, we're going to operate the business in this particular way. We're not going to make material changes. We're not going to change our accounting. We're not going to make events.
Settle everybody's salary.
And so really, representations and warranties are about risk allocation, and they're about information. It's also an opportunity for the buyer to capture as much information about the company that it's buying, knowing that it's never going to have a better chance to get people to focus on, records. So you'll see schedules like, the company has X amount of, seat licenses for Microsoft Office, and buyer wants to know how many licenses do you have? Is everyone covered? And buyer would much rather have the company go through the process of scheduling and providing all of that information, whether it exists or not. And so a lot of times when you're doing informational schedules, you're actually having to go out and create new lists that don't otherwise exist. But the buyer, understandably, wants to know exactly what it's buying, and really to have at the end of it not have to, inherit a bunch of messy paperwork and figure out, what it bought. So indemnification goes hand in hand with the representations and warranties, and really hand in hand with the purchase price. what happens if the company's representations and warranties aren't true? What happens if a lawsuit is filed the day after closing? Was the company completely forthcoming with disclosing all of its, all of its skeletons in the closet? And so in this case, the definitive agreement is going to have indemnification of the purchaser against breaches of representations, warranties, and covenants made by the company. Indemnification will typically have a cap. We're going to put, a lot of times that might be the escrow amount. We're going to put 5%, 10%, 15% of the total proceeds in an escrow account, and that's going to be the buyer's sole recourse if there are these issues post-closing. Obviously, from the company's point of view, you want certainty on what that cap is, and you want that cap to be as low as possible. You want to keep as much money as you can out of the deal, and while the money is in escrow, you want to have some confidence that you're going to get that money back. I think I'll cover these in the next slide. So in this case too, what's covered? Cap, how much, what's the seller's total exposure? Basket, what's material? Buyer, if there's a $10, a de minimis liability after the closing, buyer's not going to have a right to bring that claim, but after some threshold, which is typically a percentage of the deal price, half to 1% of the deal price, that's kind of the agreed upon materiality threshold. Hey, claims or damages in excess of this amount are indemnifiable, and you can fight with the buyer over whether or not that amount serves as deductibles, like you're paying an insurance policy, or the company will be on the hook for first dollar indemnification. And then finally, survival, for how long? Buyer wants, to tie that money up for longer the better. The company obviously wants the money back sooner. Indemnification will also have special indemnities, issues that come up in diligence. Every company has issues that come up in diligence. No operating company, doesn't have ordinary course liabilities, and sometimes they may have extraordinary liabilities, but there's still a reason to do the deal, and so you might set up an indemnification scheme around that particular issue. Company's got litigation, buyer says, we're going to estimate that the total exposure on this claim is X, but if it turns out to be more, we're going to have to, we're going to get some of our purchase price back, and so we're going to set up a special indemnity to do that.
But just on the cap, though, it's a cap, it's not, right? I mean, they shoot.
Yeah, I mean, ideally, a seller would want a firm cap where the buyer's only recourse is out of the escrow, which is a portion of the purchase price. Obviously, there are situations where a buyer could spend $50 million and not anywhere close to that value because of issues that come up after the closing. And so fundamental issues, issues like ownership, issues like authorization, authority to do the deal, sometimes compliance with major contracts, sometimes ownership of IP might survive for longer because their buyer consider those to be fundamental. These are fundamental representations on which we're basing this deal. If they turn out not to be true, whenever, we want the ability to get all our money back.
So Section 8 of the term sheet is about target dates, and I think that we've emphasized that you really don't, once you get into this M&A process, you really don't know how long it's going to take and where this journey is going to lead. So I think this provision here is more aspirational, and I think it's, in this case, it's the objective of the purchaser is to keep the seller excited. So if you read the first sentence, it says, purchaser expects that a definitive agreement could be executed, approximately 6 weeks after the seller provides all due diligence materials, right? So the biggest unknown variable is provides all due diligence materials. So if you don't have a clean company, so we'll give, like Matt said, give me the list of all of your patents, and then they start reviewing that and say, well, what about this issue? Well, now we need to do another freedom to operate investigation. It can just kind of keep slippery slope, and you keep sliding down. And so when all the due diligence materials are provided, could be a long time. So this sounds like you're going to get the deal done in 6 weeks, but it actually is, could be a lot longer than that. And then the closing will occur as soon as practicable following the signing of the definitive agreement and satisfaction of all conditions to closing. So as we talked about, the conditions to closing could be lengthy, right? Regulatory approval, chasing down a bunch of third parties to get their consent. So we joked around about closing really quickly. Some deals are smaller and there's not a lot of hair on it. It's pretty straightforward. You can sign and close on the same day, right? So you sign, there's minimal closing conditions, and the people get their money that same day, right? There are other deals that can take a lot longer, right? So these target dates are really just that, they're targets.
Exclusivity, this is another major, critically important part of the term sheet that virtually all term sheets will have. Certainly from the perspective of the buyer, it is probably the most important provision in the term sheet other than, price, or really on par with price. This is the exclusivity provision. It's sometimes called a lockup or a no-shop, where the company agrees and it's binding that once it accepts this term sheet, where both parties are going to march towards a deal, and the company is not only going to talk to other buyers, it's not going to respond to other buyers if other buyers contact them out of the blue, and in some cases, depending on how the exclusivity provision is worded, it's going to tell the buyer that you're negotiating with, hey, so-and-so contacted us, or we got another term sheet for this. I'd say an exclusivity provision is both fair and appropriate from the perspective of the buyer. The buyer does not want to invest the time and resources to kind of really kick that due diligence into high gear, pay its lawyers to prepare documents and go through this really intensive process without some certainty that, hey, if we execute on what we've mapped out, that we're going to get this deal. The buyer's worst nightmare is agreeing to a deal in concept and then that deal being used as a stalking horse so the company can get a better offer. And companies with tons of leverage will negotiate hard on exclusivity. You may want to give a very tight exclusivity window because you know that the best driver to increase really terms is the threat of competition. It's having the best way to move a buyer off up in valuation is for that buyer to think that there's another buyer sitting around that will make a better offer. And so this is both a customary and an appropriate provision, but it's also a big give for the company to give up. And so, our advice to sellers is don't give this away for nothing and don't give the buyer more, don't make it easy on the buyer. So really, do what you can to maximize your competition or your perceived competition, whether or not you're talking to another buyer. Part of this is giving the perception that you might be.
Isn't it related, very strongly correlated with the target date in a way? You don't want the target date to be prolonging and then they lose the exclusivity. They're just.
Well, typically, yes. I mean, conceptually, it should be that, hey, we anticipate we need 6 weeks to get this deal done. And so we're going to ask for, 6 or 8 weeks of exclusivity. What often happens, because it's not uncommon at all for those exclusivity periods to run, is a smart buyer will have calendared the date that exclusivity period ends a couple weeks before it's getting anywhere close to looking like it's pushing up against it. They say, hey, things are going well, but company got to agree to extend this. For us to continue negotiating in good faith, we need to extend our exclusivity period, to make sure that we're covered. And, you can work on deals where that happens 2 or 3 times.
Yeah, Matt and I were talking about this before the presentation, but we represented the sale of a company to a large public company, and the exclusivity period was coming to an end. And so we and the main guy in the company were getting contacted all the time, hey, we need to extend the exclusivity. And we kept saying, we want to do this deal with you, but we're not going to extend the exclusivity because we wanted to keep the pressure on them because they were basically just, of course, dragging us, through all kinds of due diligence. It was taking lots of time. No, we love you guys. We want to do the deal. but implicit in that is we're not going to extend exclusivity because they keep jerking us around, we might let go. So it can be very effective.
I can remember one time, my former firm representing a buyer buying a strategic asset, and the buyer had an in-house kind of investment banking person who negotiated the term sheet, presented it to us after the fact. It did have an exclusivity provision in it, and we said, you should not proceed with this deal without an exclusivity provision. We should amend this term sheet. The client said, that's not how deals, this is in the entertainment industry, that's not how deals are done in this industry. We have a handshake deal, we're not gonna go do that. 6 weeks later, I remember coming in on the Saturday before we were gonna sign that Monday to get a notice that they had sold the company to someone else. And it was a painful lesson for the company, that's the one instance I can think of where a otherwise intelligent, well-counseled buyer decided to proceed without an exclusivity provision, and the company, used that deal to get a better deal. So this too, kind of tacking on to this concept is, hey, all right, we have a mutual agreement in concept to pursue a deal. We don't want you to go through and reconstruct your cap table after we've settled on this. We don't want you to go, we're familiar at a high level with how you're compensating your executives. Companies resist the urge to go change that right after the term sheet's signed.
So this is the second binding provision. Remember up at the beginning, Matt went through and highlighted all of the provisions that are binding. So this is the next one. There's a lot of words here. But basically, I'm going to short form this. This says we don't have a deal until we have a deal. And that deal is the definitive agreement. So we can work hard, we can kick the tires, we can do all these things, prepare documents, but if we don't reach the final deal, we don't have a deal. And even if we take all these actions, that's not a representation or warranty that we're going to somehow get the deal done or be legally obligated to get the deal done. It also says that part of this says that it's also foolish to believe that you're going to do a deal, and so don't take steps with that expectation because it may not happen. This also says this provision provides that each party is going to be on the hook for its own expenses. So if the deal doesn't get done, you can't look to me for any damages, right? Consequential damages for not getting the deal closed. So this is basically designed mostly to help the purchaser. Each side can walk away from the deal whenever they want. And again, there's no deal until the actual final documents are signed, sealed, and delivered.
I would say, but having said that, even though virtually all term sheets are set up this way, most of them close. And once you get a big company, once the wheels are turning internally and they get a term sheet improved by their internal process, that's to a seller's great advantage, because once that train starts moving, they're very likely to close absent a significant event. And so it's not as daunting as it may sound.
Jamie could actually afterwards share a story of a company that we sold to a large Japanese buyer, a software company, and it was a hot mess on the accounting side, on the legal side. We got pulled in right before the sale of the company. The Japanese company bridged them $500,000 just to clean up their books and records. So they really wanted to buy the company. And so to Matt's point, sometimes I'll do whatever it takes, right? That was quite the acquisition.
Carlos, how often do you see a provision in a non-solicitation side of things where they're not talking to deals, where they'll pay the seller for that period? They'll advance $50,000 for a smaller company. I've seen more of those lately.
So the potential acquirers advancing money to the seller?
Yeah, for that exclusivity.
Yeah, I personally don't see that too often. It's really, more in the style of this, where we sign a term sheet, let's see if we can do a deal, and it would have to be a pretty attractive seller for them to fund their money just without any strings attached.
It's all leverage.
The last one I saw was a seller who really wasn't interested in selling, not marketing itself. The buyer was very interested in selling.
Well, they wanted to secure that, and so they were willing to pay a little bit of money to do that.
Most of the time, if anything, it runs in the opposite. You'll see a provision that a buyer will say, hey, if we go march down this path and you decide, company, not to close, you're going to pay our transaction expenses. And that would be, or a breakup fee. Again, not in the majority of deals, but certainly that's more common in that situation.
Yeah.
So we're getting close to the end of the term sheet. This is another binding provision. And in this term sheet, this is very simple. Basically, it says that each party pays for its own fees and costs. Right? There are some times where a buyer will try to push some of its fees and costs onto the seller. But I think this is simple and fair. Right? There are two parties trying to get together to do a deal. And so very simply, each party pays its own costs and expenses.
Confidentiality.
Situation?
What's that?
Is that the customary situation where each party pays its own?
Yeah, if something else proposed and we're representing the seller, we're going to counsel our client to really push back on that. I don't think it's fair.
Confidentiality, another binding provision. As we outlined at the beginning of the process, hopefully there's an NDA in place. This is now the time, oftentimes that NDA maybe is 3 or 6 months old. We want to dust off that NDA and make sure it still works. Obviously, from the company's point of view, the company wants to make sure that it's about to, prior to signing the term sheet, it may have provided some high-level financial information. But now it's really the time for the buyer to kick the tires, may want to get in and look at the company's sensitive technical data. So it's really important, obviously, from the company's point of view, that process is well managed and that those the buyer is subject to confidentiality obligations. Similarly, the buyer wants to make sure that it's the fact that it's in negotiations to buy the company and the existence of the term sheet is confidential. That sort of goes hand in hand with that the exclusivity concept we're talking about.
I got a question. So I've had friends who have been in situations where companies have approached them to acquire their company, essentially just to kind of see inside the kimono and find out what the secret sauce is without necessarily wanting to acquire it. And can you talk a little bit about the types of things that a seller, should be suspicious of, kind of in that respect?
Well, that's a good question. That's something that I think is, again, really, really deal dependent, right? So let's say in this case they actually get to an NDA. That provides some contractual protection, but if you're a small company having to litigate a large company over an NDA and whether they breach confidentiality, you probably don't have the budget to do that. So I think I think a lot of it is kind of a gut check, right? As you start to kind of establish a relationship, take the steps to test for the buyer to test whether you really have a serious seller. And it could be moving them into the term sheet or seeing if they're willing to start to invest some time and effort in the process. But again, sometimes sellers are really eager to do a deal and they might just head down that path without kind of really thinking through the process. So it certainly can happen, but I think with the right advisors, you're at least going to put some of the contracts in place and signal to the buyer that you're running a serious process and that they deviate from the consequences.
And that's really a bad faith action, but you really want to avoid that. It can happen. With a serial buyer, it really shouldn't happen, and the check on to prevent them from doing that is a reputational hit they would get. That got out. Sometimes your best recourse is to say, hey, we trusted Google to come in and look what they did. Google buys a company a week. Other companies would hear. Google doesn't want to develop the reputation of doing that because every founder's afraid of that. But most of the time, that's a rare, you kind of know that when you see it, when something just doesn't feel right about the buyer's intentions. And you'd want to deal with that, you'd want to stage your most sensitive confidential information at the point where you were most certain that you had the deal, and in very rare cases you could set up something where...
But you wouldn't share all the secret sauce before you have a term in place.
Of course not, right.
So give them enough to keep the deal going forward. I wish we had a secret question that works in all cases, but we don't. So,
just a good governing law, binding, more often than not, you'll see a term sheet governed by the state of Delaware for the reason that these non-binding term sheets with a part of them that are binding have been litigated and tested in Delaware, and there's law that speaks to this situation. If we saw a term sheet that had a state governed by Tennessee law or something, we would want to understand what the law was around binding provisions and lockups and non-binding provisions in that state. And Carlos made this point earlier, but this is the deal. We don't have a deal until we have a deal, but our conceptual deal, this is it. It's all in this term sheet. There are no side deals. And again, if from the seller's point of view, if there's an important term and it's not, don't rely on a assurance from the deal champion on the other side, the buyer. You really want it's important to put in the term sheet because this is really meant to reflect all material terms. And occasionally you'll run into situations where, hey, we need to change this term sheet. There's an issue with the valuation, the numbers didn't pencil out, or there's some other issue that surfaces that makes a part of the term sheet unworkable. You might amend it, and that will happen.
so I decided to repurpose this slide for the Series A term sheet workshop. So as a seller, Beth pointed out that $50 million that gets adjusted and tweaked and reduced and maybe even increased. How is all that money distributed? So we're going to turn on the liquidation waterfall here. And there's a lot of components that go into making that calculation. So as Matt mentioned, transaction expenses, you might have to pay off some debt. To change in control bonuses, you may have the employees that are terminated, so you have to pay them some money. You might have some warrant holders that exercise their because they're in the money, as well as option holders, so they become, in most cases, common stockholders. In some cases, they might become preferred stockholders. So all of this needs to be calculated, right? After the closing, there could be the net working capital adjustment that Matt reviewed. And also, if there's any money after the conclusion of the escrow period, that needs to get distributed. So this isn't simple. You need to prepare a detailed financial model. This model is going to be customized. This is the model that we use for this preferred stock term sheet. This model does have something that goes through a liquidation waterfall, but each model is going to be different because the preferred stock might get 2 times its return before the common gets any of its money, but it all needs to be modeled. And this is a nice segue into, we've got just a few more slides for Q&A. We thought that it would be important to talk about some of the key issues. You may have a company and you're not quite ready to sell, right? But you're thinking about it. You might even be starting a company with that goal in mind, 3, 5, 7 years down the road. So if that is your goal, it's important to think about some of the issues that will affect an eventual M&A deal. So one is, so I'm going to go through quickly through a list of things. These are some of the points that I would tell you when you're starting a company, an incorporation. One is you need to, along the way, make sure that your company continues to own its secret sauce. You might be filing patents. You need to have good patent counsel to help you do that. So there's kind of what I'll call the hard IP, patents, trademarks. Make sure that you get the right help to really protect that. But along the way, you have to sign NDAs. All of your employees and consultants should sign proprietary information agreement and invention assignment agreements, so that all of your company is putting its arms around the secret sauce and increasing the value of the company. Similarly, and this goes back to the spreadsheet that we were just looking at, you've got to keep a good handle on the ownership of your company. Who are the stockholders? Is the stock issuance being approved? Are you properly issuing warrants and options? But really keeping track of that so that when you get to the finish line, and I can guarantee you the buyer's going to look at this really heavily, right? They don't want to buy a company and find out that there was some unknown stockholder that shows up 6 months later and says, oh, you owe me $5 million. So they will kick the tires pretty hard on this, but you internally need to know this so that you can figure out how to split the proceeds. Again, blocking and tackling, good corporate approvals along the way. Again, stock ledger relates to just keeping track of the information. You want to comply with securities law filings and stay out of trouble. You want to have good business contracts, quality agreements. Sometimes that form that you find on the internet may work, and sometimes it doesn't. So be very careful. From an M&A perspective, assignment provisions, we talked about the changing control and the consents, right? So if you're thinking about M&A, you need to really focus on that provision and how that might play out in a sale of your company. And then termination provisions, the buyers may say, hey, we don't have this contract anymore. Can you get out of it and terminate the contract? So just things to think about. Financings, so this goes back to some of the earlier workshops. Liquidation waterfall, how are the proceeds split between the preferred and the common? Obviously that really plays out in a sale of your company. Drag along rights is another example. So the board approves the deal, you get a majority or a supermajority of the preferred stockholders to approve the deal. There might be a provision in those documents where you can drag along all the common, right? So if you're the founder of a company and you only have common stock, you may want to think about that drag along provision and whether you just want to be dragged along if an M&A situation arises. And also approvals. We talked about that biotech company where each of the series of preferred stock had an approval right for the M&A. That affected that deal. The Series C was just one stockholder. They didn't like the terms. So we had to go back to that guy a couple of times and alter the terms of the deal before he would approve it. So all of those kind of financing terms, not all, but some of the terms can play out in an M&A situation. Maybe at startup, but pretty soon you're going to have to start thinking about financial statements in your business records, getting, maybe starting with a bookkeeper, moving to an accountant, and there's some CFOs in the room. Just kind of keep upgrading the quality of your financial accounting as you go, and keeping things organized, right? Your IP records, your employment, corporate contracts. And it really comes down to, if you're about to sell your company, are you ready for in-depth due diligence? Like guy with the and that's going to look into your company with the magnifying glass and really check things out.
Just one that does an incredible list. I'm going through a deal right now where there's one other thing I can say: be careful of side deals or contracts, or CEO or president said this and then, said they're going to give this options and it doesn't happen, and then like right now we're ready to close. We got 3 people that just came out of the woodwork showing some side deal email that said they were to do additional stock. So just be real careful. Get professional advice when you're setting all that stuff up and doing it.
And they have a lot of leverage right now.
They have a lot of leverage because right now they're like, you owe me this, and we've already given the buyer, the cap table, and now we're trying to adjust it, and it's just a nightmare. So I would say, and this was a company that started out with LegalZoom. They did the whole thing for 2 years using LegalZoom, and then they brought in professional capital. So now they're trying to unwind all this stuff in the first 2 years. It's just a nightmare.
That was an unsolicited testimonial from the accounts guy after that. So. Okay, assemble the right deal team. This should be straightforward, but this is a several-month process, and get organized and do it, out of the gate. As far as management, key players internally to drive the deal. If you're working with an investment banker, attorneys, accountants. Investment bankers, engagement letters, performance, and fee details. This is just something that comes up over and over and over again. Are there any investment bankers? Okay, well, since you gave us that we're going to say present company excluded.
be very careful when you read investment banking engagement letters. They're not like law firm engagement letters or accountant firm engagement letters where those letters typically say you're gonna pay us this amount per hour for this amount of work or whatever, but it's straightforward. Investment banking engagement letters are rarely straightforward, and they should be negotiated. You want to be very careful on things like how is the purchase price calculated. For example, if you're buying a company if the purchase price is $50 million, but $10 million of that is going in escrow, the banker's going to be paid on $50 million or $40 million. The right answer is they should be paid on that second $10 million, on that $10 million when and if it's released. And so but expect, if you don't look at it for the definition of the aggregate consideration, to pick up contingency payments, earnouts, escrows, and it's very rare that a company ends up paying their bankers less than they expected them to, and it's often that it ends up, and it's not at all to discount the value of investment bankers, particularly in M&A. It's just important to know what your deal. It's important to know how you're going to calculate their compensation, and if you terminate that engagement, what's the fee tail? All of those engagement letters will have a provision that says if you do a deal, while we're your bankers or for a period of time afterwards, we're going to get paid on that deal, and so you want to just be aware of how that works and how long it is, and absolutely use counsel to negotiate those letters.
Can I just add one thing?
Yeah.
So you might sell your company once, and if you're lucky, maybe you'll sell a few companies. But these guys are professionals. They're deal people, and they do this every day. So this is like Matt talked about the term sheet being outlined of the deal as a good opportunity for the seller to get deal terms in. As the seller that's engaging an investment banker, this is your time to get these terms right. Because once these folks are taking a lot of risk in terms of trying to get deals done and getting a percentage of the deal, they'll fight really hard if the deal's done to get every last cent. So it's really important. They're charming, right? They're good at bringing in business, but they're not your friends until you've got a good agreement in place with them.
Term sheets, critical outlines of deal. We've hit on this point a number of times. Deal communication, internal and external. So confidentiality, in our case, we reviewed a confidentiality provision. We talked about the deal itself being confidential, so you're not going to communicate that to the outside world. You may not communicate it to everyone in your company as well. And so you have this is something that you should establish at the beginning of the process. Hey, who are we going to bring over the wall? And those folks are going to know about the deal and work on the deal. And who within the company are not going to know about the deal, and how are we going to approach that? Due diligence, organization, and best practices. Again, first impressions go a long way with due diligence materials. You cannot be too organized, and you will gain a huge amount of deal momentum if you're organized, you follow good practices. And what you want to do as a seller, ideally, is just push it after you sign that term sheet, and you make available in an organized way all of your diligence materials. Put the onus on the buyer to say, okay, now you got to get through them as quickly as you can, and we're going to go. You don't want to get caught up in this situation where you present, half-baked information or incomplete information. The buyer starts to get its, ears up, thinking there may be skeletons, and really digs in, and then you're in a, much more extensive.
In Alan's example, if that's coming up, you imagine the buyer's kind of wondering what else is out there, right?
That's exactly what they did. They were 9 New York law firm partners, bill $1,200 an hour. As soon as they see one thing, they start bidding.
Yeah, no, and it really is, the presumption. If you're well organized out of the gate, it's like anything. It's like buying a house. You go and you're on the open house, and if that house is super clean and immaculate, it conveys a certain impression. If there's a bunch of dirty dishes in the sink, you're going to assume, what else is wrong with this? Where's, what's kind of behind the, I'm going to have to do more of a deep dive to really make sure that I'm not stepping into something unexpected. Document preparation, negotiation. Here I would just say, absolutely, use the benefit of work with your advisors out of the gate, it's not really too early of a spot to at least let them know, hey, we're considering this, and really, you know, invest in the term sheet, and, you know, expect after you sign that term sheet, as much as you may think that's your deal, you know, the deal's coming in a stack of documents that's closer to that.
But our experience, the term sheet's 7 pages, and Matt mentioned that the merger agreement's 80 pages. So people can get through a term sheet, and a lot of business people will want to do it themselves. It feels good. You feel like you've accomplished a lot. And I understand that. We understand that. But there's some key things that could really influence the deal. It's the outline of the deal. So if you're going to do it by yourself, be careful, right? But at a minimum, have your buyers take a look at it. And you can run the process, but they may spot something that actually could have a very important effect on the deal down the road.
Timing issues, schedule exceptions, third-party consents, getting approval. You know, I mean, this really covers a range, a number of issues that can come up. Schedule exceptions is that disclosure schedule document we're talking about. That is it's going to take a long time. It's something that is prepared collaboratively with the buyer across a lot of different, you know, will touch every aspect of your company. So expect to spend some time on that. You know, anticipate in advance third-party consents, any gating items, things outside your control that you may need to get, you know, every third-party consent that you can make go away. That's one less, you know, contingency on your transaction closing, and, you know, one step closer to deal certainty. Then deal approval. Know what constituents within the company, you know, need to approve the deal. Understand the buyer's approval. A lot of times, you know, big companies operate on their own clocks, and sometimes, you know, their transaction may need to be approved by their board, and it may take 2 weeks to get it approved once it's done. I've had that happen, and so we really understand, you know, okay, who needs to sign off on this, you know, for this to be a go. Managing the deal with 21st century tools, really use online data rooms electronically. You know, it used to be the case that you would go into, you know, you'd show up at a company's office and there'd be a room set up, a conference room with just a whole bunch of documents. It doesn't really work that way. You don't see that as much now. Now a lot of it's done electronically. And so from a seller's point of view, scan all your documents as you go. Build your data room as you're building your company. Maintain good records all along and keep them electronically, and you'll be in a much better shape.
We could give you some tips on that, because that really is important. Just for M&A, but just operationally when you need to find things. Anything else?
I have a question. A lot of investors, or let's say somebody wants to acquire a company, they don't want to sign an NDA. How do you handle that? For example, they're looking at 50 deals a day.
Well, I mean, it's not uncommon. It would be uncommon for a buyer to say that. And I would not advise a company to go ahead without an NDA for this process that we're talking about. But in the financing process, you do see some. It's a common comment to venture investors to say, hey, we as a matter of policy, we don't, you know, sign NDAs. And in that case, it's really the reputation of the investor. Again, it's that, you know, if they're in the business of serially investing, chances are it doesn't really work for them. They're not just looking at your technology to go and, you know, use it in some other.
But on the financing side, that argument that we don't sign NDAs works for like quality venture capital firms.
Professional investors.
Yeah, but if it's the angel investor around the corner from your house, that's a different story. So it really, so that argument I think works in certain cases, but if it's a strategic investor or a company's investing in your company, yeah, I don't think you'd want an NDA for that.
Well, and you said they say they see 50 deals a day. Okay, I mean, I should have that many companies. 50 deals a day.
Managing information. The gentleman over there, you know, he was concerned about somebody just coming around and kicking the tires and taking the rest of what you've got, and, you know, 8 months later that coming up with something. How do you manage the information that you're exchanging? How do you get it back if the buyer backs up?
You have a provision in your NDA that requires the buyer to either destroy it and certify to you that they've destroyed it or return it. That's all covered.
But they may not, right? You can tell them to do that in the contract, they may not. If we help you with your data room and you're concerned about that, we can give them access online, but they can only view the screen. And they can't download the documents. Or you could have them just come to your office and look at paper documents or look at documents on screen, and they can assess something, and maybe not take notes or take notes. I mean, you have to be careful though, right? In terms of the relationship that you're building. But you can limit you can give them access, but limit how much they can take away. So it really depends on how sensitive things are.
Yeah, so last point on post-deal follow-up, key action items to track. There will be, as we mentioned, within 90 days after the closing, the post-closing audit, where you're going to resolve, you're going to look at the working capital numbers and compare the company's estimates at closing. Will typically be an escrow period. When does that escrow period end? And so we'll go through and calendar out these key milestones. Obviously, if they're milestones,
Burn out exactly a long time. And I know some people in the room, seems like a minor thing. Get your closing documents right away. Don't wait months and months, because the longer that goes, then you might forget some of the pieces of the puzzle. So I think that's an important thing. So that concludes the formal presentation. So thank you for attending. We're going to have Q&A. So we've had some great questions so far. Certainly more opportunity to ask questions. There's an evaluation form. We would love to get your input, especially about future topics and ways that we can help you through these programs further. And then afterwards, there's more networking and talk to. So you can ask questions about M&A, about financing. It's your turn.
On the earnouts, is it an all or nothing, or is it ever done on percentages? You make X percent of your goal and you get X percent of it?
Yeah, it could be. It depends on the creativity of the parties. I think, just as a general comment, because you're dealing with the future performance and some of the issues that we talked about, how it's right for dispute. If you get too fancy, right? If we get 49% of this, then we get 50% of that. It's after a while, it's hard to you have to really make sure that you can measure for whether you've reached those other trigger points. So you can certainly do that, but at some point, it's good to maybe just go back to a simple structure.
I was just wondering, when you were talking about the employees earlier, and you talked about the aggregate hire scenario where a buyer comes in, wants to buy your company, they want all the key employees that they've identified, and they want X percentage, 95%, whatever, of the other employees as well. How, as a seller, can you guarantee that your employees actually will migrate over to the new company? I mean, you can't really sign that, can you?
Well, it's a condition to the deal, right? And let's say you got 94%, or you got 87%. You could go back to the seller and say, hey, we did our best. Maybe if you give them higher salaries, more will come over. But if you can't meet that percentage and the seller still wants to do the deal, they'll look at the conditions. So, okay, we'll let that one go. That was close enough, and we'll still move forward with the deal. So there's a way, but if the buyer's going to play hardball and say, no, you didn't reach 95%, we're not going to do the deal, that's a prerogative.
I had the same question. The buyer needs to convince the employees to come and stay.
Right.
That's the environment they're going to work in.
So for some key employees, but they're going to focus mostly on the key employees, right? That's where they're going to invest more time.
I gave the same ways to both. Of course, key employees are less, but then
that's true. Well, that's the comment, though. If you want, help us get to that percentage.
Just the buyer needs to do a fair or better for if he wants to,
right.
Work for him.
Come on, just got any more questions? Anything else?
Maybe some on the other types of M&As, because there was the word triangle, there's all of these, the other ones that you outlined.
Yeah, so we can speak a little bit about, we see a lot of asset deals. And that's oftentimes favorable for the purchaser because they can step in and say, okay, we want these assets, and we'll have a few liabilities, but we're gonna park all the liabilities with the selling company and not gonna move over. There are some advantages also in the step of base the assets from a tax perspective. So we do see a lot of asset deals, but we had to pick one term sheet, so we discussed the merger. But we do see a lot of asset transactions.
Certainly, if you're on the seller's side, you don't want to do an asset deal because you don't want what you end up with after that deal is an empty shell that may just have, all the stuff the buyer didn't want, and that can be liabilities. Typically it's liabilities that the buyer's coming in and plucking all the valuable assets, but wanting to leave an entity that has some liabilities. And so, for all sorts of reasons, it's better to do as a reverse triangular merger from the perspective of the seller.
So that's the most common.
Yeah.
More, I guess, a comment in terms of tax planning and tax structure, both for the buyer and seller. I mean, a lot of times people don't think about what the tax implications are, and that gets driven directly from the structure, right? And if the buyer doesn't get their tax advisors involved into the very last minute, sometimes that can spoil the deal of the left out too.
Yeah, I mean, you notice in our term sheet, it said that the tax benefits of the deal are going to flow to the buyer. A lot of them don't say that. A lot of them are silent. And you're absolutely right. There can be a significant, as far as who gets to claim the compensation expense, for example, there can be a massive amount of money that is in play because of that. And so the tax piece is very important.
Okay, well, we'll conclude the program now. This is where we work, so we're going to stay here for a number of hours. If you have any additional questions or the food is still going, please stay and network some more. So thank you for attending.